To understand the significance of the beneficiary principle under the law of trust, let's have a brief look of the law of trust itself. The law of trust can be looked as a legal structure in which property is held in trust or an obligation with respect to the benefit of the property. It may give a trustee or other or both dispositive discretions in relation to the trust property. The law of trust is unique because it is founded on the division of property rights into legal rights and equitable rights. In essence, the law of trust permits a division in the ownership of the trust property between the trustee and the beneficiary so that the trustee is compelled to act entirely in the best interest of the beneficiary in relation to the management of whatever property is held on trust. There are four main types of trust, which are express trust, resulting trust, constructive trust, and implied trust. Furthermore, the law of trust functions to facilitate the law in a way that allows individuals to leave property in another way instead of primogeniture. It also helps avoid irksome feudal incidents and taxes, along with helping to set up business ventures. But the principal core functions of the trust is to separate the beneficial interest in assets from the powers that go with having those assets.
Hi, my name is Faith, and I'm going to be introducing the concept of the beneficiary principle. The beneficiary principle requires that an express trust benefits an individual or individuals instead of merely existing for a cause or purpose. This is a rule first discussed in the case of Re Astor's Settlement Trust, which decided that any purpose trust with no ascertainable beneficiaries will be deemed void. One of the main rationales is that a trust contains equitable rights to be enjoyed by a beneficiary, which can be enforced if the assigned trustee refuses to honor these rights. In contrast, purpose trusts are not meant to benefit a single person. Hence, no one person would have the right to take action should a trustee fail to honor the terms of the trust, and this idea was iterated in Morris and Bishop of Durham. An important case that discusses the avoidance of enforcing purpose trusts is Leahy, an Attorney General for New South Wales. In deciding that a trust for such order of nuns to be selected by the trustee was a void purpose trust, Viscount Simmons outlined two ideas for this decision. Firstly, that the beneficiary being the order of nuns instead of individual nuns created an uncertainty that the trust would continue indefinitely, which goes against rules pertaining to perpetuities, which will be discussed further in this presentation. Secondly, since the trust would only benefit the purposes of the order of nuns, no one nun could benefit from the trust individually. Another notable reason is that courts at the time also became aware of the growing British economy, fearing its development would become stunted if money was simply vested in abstract purpose trusts without being spent and circulated back into the economy. So, to reiterate, valid trusts must benefit persons, even corporations, but they cannot be made for a purpose or to an object. And along with the beneficiary principle, it is vital that the terms of purpose of the trust is certain, with sufficient guidance on how it would be enforced. For example, in Re Barlow's, the terms old friends as beneficiaries was found to be too uncertain, as the court could not objectively ascertain what would be meant by old friends, and who could fall under that category. Hence, it is evident that any murkiness in a trust terms could negatively affect its enforceability.
My name is Abija, and I'll now go into the significance of the beneficiary trust. As stated above, the basis behind this principle is that there must be a human beneficiary who would be benefiting from a trust. It was stated in Morris and Bishop of Durham that a trust must have an identifiable person for whom the trust is set up. Without such a person, the trust would be void. Beneficiaries also play an important role in ensuring the trust is properly managed according to the terms of the trust that were set up by the settlor. Firstly, this principle operates in a way that prevents a trustee from acting in a way that would not be for the benefit of the trust. For example, some trustees may fail in their obligations by not taking proper advice when it comes to investing the trust money. And in such a situation, it is important that there is someone present who can take action against the trustee for failing in their duties, whether or not the failure was for the benefit of the trustee themselves. In such circumstances, it is obvious that the settlor would not be able to take any action against the trustee, as they would have stepped out of the trust. So the only person left is the beneficiary. And this is because the court cannot take action against the trustee, and there is no officer in government who has been placed in charge of ensuring that trustees are held accountable. Secondly, the principle has been deemed to be of great importance because within the concept of trust, there exists two ownerships: legal title, which is held by the trustee, and equitable interest, which will be enjoyed by the beneficiary. Because an equitable interest will always exist within a trust, it is important that it is attached to someone, as it is not possible for an equitable interest to exist without being owned. The maximum of equity that is being upheld here is equity upholds a vacuum. So this principle ensures that the equitable interest in the property of the trust is owned by someone, and this person is the beneficiary. Thirdly, the reason for the importance of the beneficiary principle is linked to the rules against perpetuity, which basically provides any trust can only exist for a predetermined time frame. The rule limits the maximum years that a trust could operate, because if the trust operates indefinitely, it may be difficult to ensure proper management. The rule is further divided into the rule against remoteness of future vesting of beneficiary interest and the rule of inalienability. The rule against remoteness of vesting requires that future trust interests, that is, interests that do not take effect immediately, must be certain to vest within a defined period of time known as the perpetuity period. It provides the maximum time that a trust can be validly postponed. There must be a specific time for a beneficiary to be able to claim their rights in the trust property. However, it is possible for this time to be delayed based on conditions set up by the settlor, but how long the delay will be needs to be specified. An example could be that the beneficiary should reach the age of 25 years old before acquiring the property, as in Saunders and Vautier. Next, the rule against inalienability prevents the property from being bound indefinitely. The common law perpetuity period for a trust is 20 years from the date of creation, or for the lifetime specified in the terms of the trust plus 21 years. The case of Pan Kin Thin and Pan Kwam Yang recognize the principle against perpetuity. So, in order for these rules to be satisfied, the beneficiary needs to be identified, and that way the terms of the trust will be clear when they receive their interest and for how long they are to enjoy them. The UK enacted the Perpetuities and Accumulation Act in 2009, which provides that the perpetuity period is now of 125 years, but Malaysia still uses the common law perpetuity period, which is 20 years. Therefore, the trust must come to an end at some point in order for it to be enjoyed, and where it does not come to an end within the period, it would be void for offending the rule against inalienability. Additionally, as the principle observes the rule against inalienability by ensuring there's an identifiable beneficiary, this therefore prevents a trust from being formed for an abstract purpose. If a trust is formed for an abstract purpose, it would be deemed as void because the money will keep getting invested over and over again, as the purpose may go on forever, meaning that the trust will not come to an end. In the case of Maurice and Bishop of Durham, the trust created by the bishop was considered to not have been a charitable trust because it was not limited to charitable purposes, and there was no obvious beneficiaries, as there was no criteria that could be used to determine whether someone was qualified as a beneficiary under the trust or not. In Re Astor Settlement Trust, the trust was created for understandings between nations and preservation of independence and integrity of newspapers. But because there were no clearly identified beneficiaries, the trust failed. Other cases that could be seen that did not have clearly identified beneficiaries are Re Shaw and Re Nottage.
Finally, the beneficiary principle has been challenged on many occasions, but it has been argued that abolishing this principle completely will end up enabling trust tools for mischief and allow persons to commit offences like tax evasion and also create trust for illegal purposes.
The first exception to the beneficiary principle is when there's a charitable trust, which are trusts made for charitable purposes, as from the face of it, it doesn't seem to be for the benefit of any single identifiable person. There are two key requirements for a trust to be considered charitable under the Charities Act of 2011. The first one is that it must have a charitable purpose as defined under Section 3.1 of the Act. The second is that the charity itself must be able to demonstrate through activities that it has a sufficient benefit for the public or part of it, as stated under Section 2.1b of the Act. Charitable purposes has been defined in the case of commissioners for the purpose of income tax and PEMSL as four main categories: the relief of poverty, the advancement of education, the advancement of religion, and any other thing that may be beneficial for the community. This has been adopted in the case of Re Abdul Gun Abdulasa here in Malaysia. Distributional certainty is not required under the general principle established in Modridge and Thackwell. Hence, there is not really the certainty of object that is usually required for trusts. The Charity Commission is responsible for overseeing charities and making sure that the trustees are administering their job correctly. If any action is required to be taken against the charity's trustees, this is done by the Attorney General, who acts on behalf of the Crown, who is responsible for ensuring that property belonging to a charity is administered correctly. In Malaysia, the power of the AG to enforce charitable trusts is found under Section 9.1 of the Government Proceeding Act of 1956. Hence, for charitable trusts, there is no real importance for the beneficiary principle, as the trust is protected through another mechanism, making the beneficiary principle less significant in that aspect. The law also appears to be willing to compromise on the beneficiary principle if it is for the greater good of the public. The second exception is trusts of imperfect obligation, which have four categories, named in the Re-Asters settlements case. These are trusts relating to tombs and monuments, trusts for the provision of masses to be done in private, trusts benefiting specific animals, and miscellaneous trusts. These are an anomalous category of trust. The reason why such purpose trusts are permitted to exist appears to be unclear, as it has not been fully explained yet by the court. In the case of Re-Asters settlement, Judge Roxburgh acknowledged the explanation put forward by Sir Arthur Underhill, who said that it is a judicial concession to the human weaknesses and their sentiments. Hence, the beneficiary principle appears to be less significant than the human feelings and their sentiments and their weaknesses and to the things that they hold dear to themselves. There is no separate mechanism in place to oversee these trusts. However, they are usually small enough for their scope to be controlled by the courts, and the courts have tried their best to keep the application of this exception very limited by categorizing it as a charitable trust if possible, like in the case of Re Hooper, where the care of a tablet window at a Church of Islam, which could have been taken to be under the category related to monuments and tombs, was actually categorized as charitable. Another example of this will be the case of Re Hetherington, where money left for masses to be said in public was said to be a charitable trust, as it gives some sort of public benefit. In the case of Byrne and Keane, however, money left for masses which was assumed to be in private was said to be under the exception of imperfect obligation, as there was no real public benefit. It would appear that there's a bigger significance for the actual role which the beneficiary principle plays, which is to ensure that there's a person who is able to take actions against trustees if ever there's any breach of their duties, or to actually enforce these beneficial rights. This is because courts do not seem to be more in favor of charitable trusts rather than other trusts which falls under the exception, as even though they do not have the beneficiary principle, they do have a body and system in place that is there to oversee the trust.
Courts may also disallow the trust entirely if they find that it was a trust that leaves too much discretionary powers that could lead to future issues. This were the case of Re and the court, where the testator left the trust to be used for some useful memorial for himself. The court considers this as too vague. Hence, it would appear that there is still some value and importance in trying to maintain the beneficiary principle, as the courts try to keep the cases within the exceptions limited and maintain that trust cannot be too vague, and for abstract purpose ensuring that the rule against perpetuity is complied with. However, it can also be argued that the limitation is not as narrow as it should be. There is still a fourth category for extraordinary circumstances, such as the case of Reed Thompson, where funds were left for a friend to maintain the sport of fox hunting in whatever way he saw fit. This was said to be valid even though it doesn't seem to fall under any particular category of exceptions, hence undermining the significance of the beneficiary principle. Although there are exceptions to the beneficiary principle, it is protected by limitations in two respects. Firstly, the trust must still not endure for a period longer than that prescribed by the rule against perpetuities. Secondly, because although the trust is said to be valid, the limit to which it can be enforced is limited, as there is nobody who can actively compel the trustee to carry on the duties. These limitations suggest that there is still much significance in the beneficiary principle.
The next topic that will be discussed is how to avoid the beneficiary principle. The first way to avoid beneficiary principle is through people trust. This element can be observed in the ruling of Reed-Bentley's trustee, where the rule is, even if there are no identifiable beneficiaries, the trust is still valid. In Reed-Bentley, the main point of legal conflict was based on the fact that the sports facility was to be held in trust for the employees of an organization. It was argued in the case that the employee were not a defined group of people, and the trust was therefore void under law. Justice Goff saw no infringement of the beneficiary principle in a situation where there are in fact direct or indirect beneficiaries of the trust. In other words, a trust might be legally binding if a class of beneficiary could be reasonably inferred by examining the circumstance. Therefore, Parkinson concluded in his journal that on the basis of the ruling from Reed-Bentley, an arrangement without a clear specified human beneficiary could be classified as a trust if certain conditions are met. The second way to avoid beneficiary principle is by a gift. This element is illustrated in the case of Reed-Bolt, which the ruling stated that the beneficiaries can override the specified purpose of a gift when it is a trust for the person. In this case, a trust was created over £5,000 of the purposes of planting trees for shelter on an estate. The Court of Appeal held that the estate owners owned the money absolutely and so could do whatever they wanted with the money, as planting trees was only a motive. Another case that can be referred to is Re Osoba, which in this case, the testator gave money to his widow to hold for the purpose of maintenance and training for their daughter up until she goes to university, maintenance of each mother, and lastly is the maintenance of herself. Later, his wife and mother had died and her daughter had completed her education, while the son of the testator had claimed for the money of surplus. Lord Justice Buckley held that if a testator has given the whole of a fund, whether of capital or income, to a beneficiary, he is regarded, in the absence of any contraindication, as having manifested an intention to benefit that person to the full extent of the subject matter, notwithstanding that he may have expressly stated that the gift is meant for a particular purpose, which may prove to be impossible of performance or which may not exhaust the subject matter. Moving on, the third way of avoiding beneficiary principle is through a contract, which this can be seen in the case of Conservative and Unionist Central Office and Borough. In this case, the court held that there was merely a contract between the agent and the principal here. However, there was no relationship of trustee and settlor. Thus, in the case of contract, beneficiary principle will be avoided.
Alright, let's talk about unincorporated associations. How does the beneficiary principle affect them? An unincorporated association implies that it has not been organized or registered as a company. Before the 1897 case of Salomon, trading companies were mere associations with rights in law and in trust. And after this case was decided, these companies were given their own legal personality. However, trade unions and other working class groups remained as unincorporated associations without a separate identity, which cannot own their own property. Instead, someone must own association property on its behalf. The problem is that this would create what appears to be a void abstract purpose trust, as the trustee would be holding the property for the purposes of the association and not its members. For example, let's say that there was an agreement for an individual in the association to keep a piece of property for the purposes of the association. There are a handful of outcomes in the context of trust law. First, this could be seen as a people's trust, and as long as there is a maximum period which the trust is to be held, this could provide certainty that the trust will end. Second, this would still be seen as a people's trust, but be deemed invalid due to violation of rules against perpetuity if there is no stipulated time the trust is to terminate. Alternatively, if this is within English jurisdiction, the Perpetuities and Accumulations Act 1964 would come into play and impose a statutory perpetuity period, validating the trust temporarily. Third, this would merely be seen as a void purpose trust. However, as Florence has stated previously, there are ways to avoid the beneficiary principle and still make valid, regulated transfers of property, especially for abstract purposes. Unincorporated associations could deviate from the trust route altogether and simply make transfers of property as outright gifts to members as an accretion to the association's capital, as seen in Re Retter. Further, treatment of this property can be governed by a contract between the members, which would be within the ambit of contract law instead of trust law. So the beneficiary principle would not apply.
In conclusion, the beneficiary principle needs to be maintained to ensure that trust was created for genuine purposes for an identifiable individual and not for the benefit of the settlor creating it. However, based on the common law rulings, this beneficiary principle can be challenged by some exceptions. Furthermore, this beneficiary principle could also be avoided by ways of people trust, gift, and also contract. That's all for our presentations. Thank you for listening.